This is Rob Morris. I'm with the Trust and Estates Department at Stark and Stark. Thanks for joining us today. We're going to be discussing estate planning in 2024. As of today, July 26, 2024, the estate tax changes have not been implemented. We're going to go over the current law, but please keep in mind that some of what we're going to cover may be subject to change later this year, and it's important that you monitor the estate tax in particular closely for any additional legislation or changes. So this is the outline of what we're going to cover today. We're going to talk about estate planning related taxes first, and we're then going to discuss a few estate planning options and opportunities. So let's jump right into it. Some fundamental estate planning documents too would be your healthcare power of attorney, a power of attorney, a will, and for some people, a revocable trust. The first three documents, the two powers of attorney and the will, are mandatory, in my opinion, for everyone. The revocable trust is dependent on your desires as well as your family structure and assets. So it's not always a good tool for everybody, but it certainly is very helpful in many situations. So it just depends on circumstances. But as far as the first three documents go, if you don't have these in place, it could be very damaging for you and your family. We'll talk about why later in the seminar. If you don't have the documents in place, power of attorneys, for example, you're going to have a guardianship, which means there's going to be an incapacity hearing. They're very expensive and time consuming. If you don't have a will in place, then that's going to result in an intestacy. That's going to cause unnecessary expenses. And intestacy has a set distribution scheme, so it may result in inadvertent heirs receiving your assets, which you otherwise may not want to have. The lifetime benefits of estate planning documents, the powers of attorney, you can pick your agents. Those are going to be the people that would assist you with your affairs if you're disabled or incapacitated. And that's a very important thing to be able to designate. For many people, that's a spouse. If you don't have a spouse, then it's usually either a trusted family member or a friend. In terms of a will or a revocable trust, you can pick your executors and co-trustees to assist you with your affairs if you're disabled or incapacitated. So let's talk a little bit about estate and inheritance taxes. Okay, the federal estate gift and generation skipping transfer taxes, currently the exemption is $13.61 million. There's also the annual exclusion gifts, which are considered by the IRS to be non-gifts, have a limit of $18,000 per recipient. Some people may get confused by that amount. They refer to it as the $10,000 limit. That was, of course, in place a number of years ago. The amount has been indexed for inflation and increased, and currently it's $18,000 per recipient. If you have a non-U.S. citizen spouse, it's important to realize that you can only give to that person up to this year $185,000. As I mentioned at the outset of the seminar, where these exemptions may go at the end of this year and certainly at the end of next year when there's a sunset of the current federal estate generation skipping transfer tax and gift tax exemptions, we don't know. So it's very important to just keep information regarding these taxes in mind. So why are these exemptions important? Many people look at the 13 million, say, I'm never going to get there, not realizing how fast their assets are appreciating. So let's just take, for example, suppose you had $2 million in assets. It's a pretty common estate valuation for many people when you include all the retirement plans, their homes, maybe they have a vacation home or an investment account. So if those assets have a rate of return, we can computate a rough approximation of what they may be worth in the future using the rule of 72. So again, this is kind of a shorthand way of thinking about how your assets may appreciate. So the rule of 72 works by dividing the rate of return into 72. So suppose, for example, you had a 7% rate of return. If you divide 7 into 72, then it's going to take your assets about 10.285 years to double in value. All right, and 7% should be achievable. So, for example, using this rate of return in a $2 million overall portfolio, in 10 years, you're going to have roughly $4 million. In about 20 and a half years, you're going to be up around $8 million. And keep in mind, your spouse's assets should be appreciating at around this rate as well. So right there at 8 million, if you double it, you're over the estate tax exemption. 8 times 2 is 16. The estate tax exemption for one person is 13. The exemptions aren't utilized properly, which unfortunately I've seen in some estates. That could result in a federal estate tax. And certainly if you're younger and you're able to keep this appreciation going for up to 30 years, almost 31 years, you're going to be at roughly 16 million, give or take, depending on how your performance is. And then certainly you're going to be over the exemption amount. So again, the exemption amounts may seem high now on paper, but by the time it comes to apply them to your estate, it really may be an issue, as we're demonstrating here. Again, asset performances vary, and that's really going to be an issue between you and your financial advisor. All right, so getting back into estate and inheritance taxes, let's talk first about the New Jersey inheritance tax here. So New Jersey used to have an estate tax that was reduced to 0 in 2018. You know, there's always an issue of whether the state will bring that tax back. But so far, over the past roughly 6 years, there's been no estate tax on decedents dying in New Jersey. New Jersey does have an inheritance tax, and that can affect a number of beneficiaries. So the main group of individuals that are affected by the New Jersey inheritance tax are unmarried couples, and then couples that don't have children. I'm going to show you why here in a second. Okay, so New Jersey inheritance tax depends a lot on who's receiving your estate, and there are different classes of beneficiaries. There's a Class A, C, and D, and that's not a typo. There is no Class B beneficiaries. All right, and in addition, the inheritance tax also applies to transfers made within 3 years of death. All right, so Class A beneficiaries are a spouse, a child, a grandchild. They also include stepchildren, but they do not include step-grandchildren, which may or may not be an issue for some people. They're all Class A beneficiaries, and they're not subject to inheritance tax. And again, this reiterates why I said at the outset, inheritance taxes vary depending in large part on who's inheriting your estate. Class C beneficiaries, all right, so now we're talking about individuals that are subject to the tax. Who are these individuals? These are brothers, sisters. They're also sons and daughter-in-laws of a deceased child. So they're Class C beneficiaries. All right. They only get a $25,000 exemption. Assets up to $1,075,000 are taxed at 11%. All right. So if you left Class C beneficiary $1.1 million, the first $25,000 would be exempt. Everything else would be taxed at 11%. And you can see that the rates go up from there up to about 16%. Finally, we have Class D beneficiaries. So that's everybody else. All right, so excluding brothers and sisters. So who might this class affect? This would apply to more remote relatives, nieces, nephews, aunts, uncles, distant cousins, and friends. They're all Class D beneficiaries. All right, there's no tax if you only leave them $500 or less. But as soon as you hit $500, the tiny exemption goes away, and the assets are taxed down to $0 at 15%. This can actually be a pretty significant tax. So, for example, if you have an IRA or a 401k and you leave it to a Class C or D beneficiary, what's going to end up happening is there's going to be an inheritance tax on that IRA or 401k. And how's the beneficiary going to pay for it? Again, they're probably going to take assets out of the IRA or 401k, and then they're going to incur an income tax on top of the inheritance tax. So right off the bat, they've already lost a significant portion of the IRA or 401k to inheritance and income taxes. So this is an important tax to keep in mind. And although the rates are at most 16%, it actually ends up costing your estate more than you think it's going to. All right. So let's go back to annual exclusion gifts. All right. So this is kind of one of our first estate planning strategies that we're going to talk about here. It's actually a very important tool. So you can give anybody up to $18,000 per person per year. All right. And it doesn't sound like much, but you can actually leverage this by doing it every single year. And suppose you live for a while. So here's an example right here, right? So you have one person, you give them $18,000 each year for the next 10 years, you've left them $180,000, right? So it sounds a lot better at 180 than it does at 18. That's a pretty significant portion of your estate that's moved over to the beneficiary. In addition, if it's a husband and wife, you can each leave the person $18,000 per person per year. And if you just simply multiply those numbers by 2, instead of leaving them $18,000 over 10 years, instead you can leave them $360,000. And again, this is just over a 10-year window. If you live for a long time, let's just say 20 or 30 years, and you continue to use these annual exclusion gifts, then you can move a very significant portion of your wealth. And again, it is $18,000 per person per year. That's increased from $17,000, which occurred here in 2024. All right. There are, in addition to the taxes that we talked about, some pretty significant non-tax issues in estate planning. All right. So one of the major ones is a beneficiary dies. So suppose, for example, you want to leave your estate to one of your relatives or even a child, right? You pass away, you leave the inheritance to the beneficiary, and then at some point in the future, the beneficiary dies. Worst case scenarios are the beneficiary dies like shortly after you. But what ends up happening to your money, right? Well, initially it passes to the beneficiary, but if the beneficiary then subsequently passes, those assets are likely to pass to the beneficiary spouse, all right? And then the beneficiary spouse does, in this example right here, has a remarriage, and that may occur particularly where your beneficiaries are young, right? You have young children, they pass away prematurely, and then the spouse remarries, then who knows where your assets are going to wind up. And the worst case scenario, too, is if your beneficiary spouse also passes away. Well, in some circumstances, these estate and family assets could wind up with the new spouse as opposed to your grandchildren or other family members. So that is a very significant non-tax issue, at least for my clients, that we've discussed in many situations. Another major issue is leaving assets to a beneficiary who's really not suitable for handling them. So the most simple scenario where this occurs, or where the beneficiary has substance abuse, dependency issues, or spending issues, right? So you leave the beneficiary the inheritance, and lo and behold, within just a few years, the beneficiary squandered it, right? They could be spending it on frivolous things if you have somebody who just spends a lot of money. Or again, in some of these sad situations where, a parent, for example, leaves assets to a child and the child has dependency issues, well, the assets could go towards feeding the addiction, and we don't want that. So that's a major issue. Unfortunately, it's becoming more and more common as time progresses. There are more and more families that are affected by these dependency issues, so it's something to keep in mind. All right. Another related issue, too, before we talk about the options here, is if you have a beneficiary who's underage. So if you name a beneficiary who's under 18, that's the threshold that I'm talking about, either assets outright or under a will, it's likely those assets will be paid over to the surrogate's commingled fund. And then the surrogate's going to sit on them until the beneficiary attains 18, and then the assets will be passed back to the beneficiary. All right. Related issue is if you leave assets to a minor beneficiary. The other option, in lieu of paying it into the surrogate, is the parents can be bonded for them, which is sort of a sad situation. You have a deceased parent, assets are left to a minor child, and then the surviving parent ends up having to be bonded for them. And these are pretty expensive bonds because you end up having to front pay the bond for the entire period until the child attains 18. So again, you're probably confused what I'm talking about. Let's use an example to explain. Suppose, for example, you leave assets to a beneficiary who's 10 years old, right? So the parent is going to end up having to be bonded for those assets until the child, in this case, is 18. So that's an 8-year period. So bonds are renewed annually, but unfortunately for these minors bonds, the parent has to front pay that entire 8-year period to the bonding company. So it can result in a very significant loss for these bond fees, which can be avoided. And one of the ways that you can avoid it is right here. You can, in lieu of leaving assets to a beneficiary, you can place them in trust. And trust can be divided for various beneficiaries, or you could have a common trust. Just depends on how you want to structure it. So what we have here on the screen is a trust that gets subdivided for 2 children. And trust 1 can be for the benefit of child 1. And as child 1 gets older and has grandchildren, we can automatically include those grandchildren on that trust. Similarly, you would have a separate trust for child 2. And as child 2 gets older and has grandchildren, on his or her own, then those grandchildren can be added to child 2's trust. So it's all dependent on how you want to structure things. Again, if you really want, you can have a group trust for the entire family. I tend to prefer individualized trust, so there's not as much fighting between beneficiaries over who receive what distributions from the trust and whether the beneficiaries are receiving, quote, fair distributions, end quote, from a common trust. So I tend to like to break them out. But again, if you want to do a group trust, we can certainly discuss that. So let's blow up that sub-trust for child 1. So child 1 sub-trust can make income and principal distributions to child 1. And then usually what we'd like to do is include discretionary distributions for the grandchildren. So what would the grandchildren receive? They would typically receive things like education payments. They may have needs dependent on their circumstances for housing and so forth. Those could all be paid from the sub-trust for child 1, either whilst child 1 is alive or after child 1 passes away. That sub-trust can continue on for the grandchildren. So it's a way of avoiding that situation that we discussed earlier, where child 1 passes away and then the assets are passing, possibly to a spouse or maybe further down the road, and then they don't wind up with the grandchildren, which can be a significant issue. If instead you funnel them into these trusts that we're showing here, the trust can continue on for the family members and avoid having assets paid over to somebody that we don't intend to receive them. All right, so to summarize our discussion here today, the first thing is, do you have an estate plan? It's very important to have those documents that we discussed at the outset, including a power of attorney, both for finances and for health care. In addition, you, at a minimum, also need a will. Whether you need a revocable trust or other type of trust, that's going to depend on your individual circumstances and your family circumstances. For more sophisticated estates, we can discuss unique irrevocable trusts that would be largely tailored to your individual facts and circumstances. We discussed important federal and New Jersey estate, gift, and inheritance taxes. Again, the federal exemption this year is $13.61 million. Where that's going to be at the end of this year and next year, we don't know. So if this can affect your estate, for the reasons that we covered during our seminar, then you need to be keeping that exemption in mind. And certainly if you live in New Jersey, New Jersey has an inheritance tax, which affects certain beneficiaries but not others. So that's a very important tax to be uh, keeping in mind as you do your estate plan. We also discussed major non-tax reasons for estate planning. Those could be to keep money within the family as opposed to passing to a spouse. That way we can ensure the assets pass to grandchildren. That's a significant one. Other ones include whether our beneficiaries are minors or whether a beneficiary has spending and or other issues which would prevent them from managing money effectively. There are many trust planning opportunities and options. We just discussed a few basic ones. They certainly go well beyond this, and I'm happy to discuss them. If you do have any questions, please feel free to call me. My direct line is area code 609-945-7617. I appreciate you for or joining me today, and wish you a happy summer.